Illinois' gun and magazine ban that a district court said is unconstitutional remains in effect after an appeals court issued a stay on the district court's injunction. Good morning. It's Illinois in Focus Daily. I'm Greg Bishop. We've got the latest in the litigation against the gun and magazine ban after an appeals court received the appeal with a request for a stay of the district court's injunction that the district court put a stay on for 30 days. The appeals court went ahead and granted that stay to continue it yesterday. So let's jump into it. If you follow me on X, then you saw this through the center square. Let's get to the ruling here from the U.S. State Court of Appeals, Seventh Circuit up in Chicago. The three-judge panel we now know is Frank Easterbrook, Michael Brennan, and Amy J. St. Eve. Ultimately, they say the district court issued an opinion holding that multiple state laws regarding assault weapons, large capacity magazines, and associated matters are unconstitutional. The opinion contains some language in the nature of permanent injunction, but this language does not appear in either an injunction order granting an injunction. They say that it must state the reason why it issued, state its terms specifically, and describe it to reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. So they ultimately are questioning the final judgment there in the district court. They say defendants have appealed and they request a stay pending appeal. Plaintiffs have responded and defendants have replied. The parties also filed memoranda addressing the problems created by the district court's noncompliance with Rule 58 and 65. Appellate jurisdiction exists notwithstanding these errors because it is plain the district court is done with this case. Compliance with Rules 58 and 65 remain necessary, essentially, if any litigant anticipates enforcing the decision through the contempt power, and we trust that the district court will enter appropriate orders promptly without the need for a formal command by this court. So we have yet to see that filed. I checked this morning from the district court. Nothing else filed other than an order a couple of weeks ago denying the plaintiff's motion for their attorney's fees to be paid for by the state. But back to the appellate court here, they say defendants' request for a stay rests largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunctions. A decision at the preliminary injunction stage is not dispositive when the plaintiffs later seek permanent relief. Our opinion indicated some matters that needed further exploration, but the analysis in Beavis shows the laws have enough support to remain in place pending the final resolution of plaintiff's suit. They talk about every other court of appeals that's addressed the validity of similar legislation in the wake of the New York State Rifle Association v. Bruin case. It's come out the same way as Beavis, the appeals court argues. The laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in other district courts' disposition lends strength to a conclusion that the Illinois statutes should remain in force until final appellate resolution. At least two other essential identical suits are pending in other district courts within the Seventh Circuit. The three suits were addressed jointly in Beavis, and they must resolve the same way eventually. The state law cannot be valid in some parts of Illinois and invalid elsewhere. This does not necessarily imply that the three cases will again be consolidated on appeal. We are reluctant to delay disposition of this appeal indefinitely just because similar litigations pending in other districts. Still, the only way to preserve the status quo statewide is to enter a stay in the suits. The judgment of the district court accordingly is stayed. The state will remain in the stay will remain in force until this court issues its mandate. So again, the Seventh Circuit U.S. Court of Appeals issuing their stay in this case. Clearly more to come, but come December 9th, when the district court's injunction would have kicked in, after his 30-day stay, he put on the order himself, would have lifted. But the appeals court yesterday ultimately saying, we are putting another stay on this. Attorney General Kwame Raoul reacting to this, saying, I am pleased the Seventh Circuit has stayed the district court's injunction. My office will continue to prosecute the appeal. The Protect Illinois Communities Act remains law of the land as the litigations pending in the lower courts. The Protect Illinois Communities Act is an important tool to prevent weapons of war from being used in our schools and on our streets, and I'm committed to defending it constitutionally. Kwame Raoul making that statement. You've got the Illinois State Rifle Association putting out this statement saying that moments ago, the Seventh Circuit Court of Appeals issued an order extending the stay of Judge McGlynn's decision finding the Illinois gun ban unconstitutional. The stay remains in place until the Seventh Circuit can hear the case, which means that the unconstitutional gun ban continues to remain in effect. While we're glad the federal district court judge Stephen McGlynn's stay would have expired on Sunday, December 8th, we are disappointed but not surprised that the Seventh Circuit Court of Appeals has extended that stay. Back in November, we were victorious when Judge McGlynn found the provisions of the Illinois ban on commonly owned firearms and accessories known as PICA to be unconstitutional. The state appealed immediately to the Seventh Circuit, so we also know that this battle is far from over. When this unconstitutional bill was signed by Governor Pritzker in January 2023, we promised to see the state of Illinois in court, and we've held firm on that promise and won't back down until our Second Amendment rights are restored in Illinois. So that's the statement from Illinois State Rifle Association on the appeals court's stay on the district court's injunction. Now, back to the appeals court's comments in their order there. They talked about a couple of other cases that are still pending in the Seventh Circuit dealing with gun bans. The Beavis case, where Robert Beavis has a case against the city of Naperville, that's still ongoing. Back in the district court, looked at the docket this morning, and they say that disclosures are going to be required by December 1st. That's already come and gone. End of fact discovery order closed by April 30th of 2025. Then end of fact discovery status. They'll have a hearing on that May 7th of 2025. And this again is in the district court in the Beavis case. Then they've got more disclosures going to be filed by May 16th of 2025. Then more reports filed. Ultimately, depositions of experts going to be conducted between August 1st and the 31st of 2025. So that gives you an indication the Beavis case in district court's not going to be settled well into late next year. The Viramontes case, that's in the appeals courts. And if you recall, that's a challenge of Cook County's ban. That was heard on November 12th in the Seventh Circuit U.S. Court of Appeals. So we'll see what the outcome is there. Nothing was posted late last night in the Viramontes case. So we're waiting on some kind of ruling from the Seventh Circuit in that case. So those are two of the other cases that are in the Seventh Circuit's jurisdiction. One, the Beavis case, apparently stuck in district court. The Viramontes case, already heard by the appeals court. And now you've got the statewide ban that is going to be heard by the appeals court at some point, but when, we're not sure. Another case, just to keep you posted here on Illinois, and that is the case of the challenge of prohibiting individuals with concealed carry licenses from carrying their concealed firearm on mass transit. The Schoenthal case, that as well, still in the appeals court. They've got briefs that are coming up due for the appellants by the 16th of this month. And then by the 15th of January, you've got the appellee's brief due, and that's going to be coming from the Schoenthal plaintiffs. And then the appellant's reply brief will be due February 5th. So again, that's in the appeals court with those briefs and being scheduled all the way through February 5th of 2025. So that as well, still kind of matriculating through the federal courts. Separately, you've got in state court, December 19th, we're expected to hear the appeals court, the, I believe, Fourth Circuit Court of Appeals here in Springfield. They're going to be hearing the case challenging the firearm owner identification card. Again, that's a state appellate court case, but that could possibly go all the way to the U.S. Supreme Court at some point. Then you get this story of what's going on with gun manufacturers and the country of Mexico, which is wild to think about. If you see this at thecentersquare.com, Cruz leads appeal to Supreme Court over Mexico's lawsuit against U.S. gun makers. Let's just read a little bit from this. From Bethany Blankley down in Texas with the Center Square. U.S. Senator Ted Cruz led a bicameral appeal to the U.S. Supreme Court requesting it to uphold American sovereignty in a $10 billion lawsuit brought by Mexico, blaming U.S. gun manufacturers for cartel violence in Mexico. The bicameral appeal was made in concert with one of a coalition of 28 attorneys general, and you've got others filing amicus briefs as well. Pretty fascinating to see that play out. So just another story to add to the ongoing conflicts here of questions of liability for gun manufacturers. We've got a similar case out of Chicago suing Glock. That's still pending in state court. But then you've got this larger question about Mexico suing gun manufacturers. All of that in the background while Illinoisans are still waiting on the outcome of gun ban lawsuits. Pretty fascinating. And this is something, I'll just touch on this briefly. We might have to do a totally different segment, but since we're talking about the courts, might as well. The Illinois Supreme Court giving different opinions over the past couple of months on the smell of cannabis and whether the smell of cannabis can be, grounds justification for a search of a vehicle. So in the case People v. Redmond, this was several months ago when it was heard by the Illinois Supreme Court, and they put out this decision. They said that since January 1st, the use of possession of cannabis is presumptively legal, subject to certain restrictions. We hold that the odor of burnt cannabis, clearly, just make sure we're clear here, burnt versus raw. So the odor of burnt cannabis alone is insufficient to provide probable cause for police officers to perform a warrantless search on a vehicle. We also hold that the totality of the facts and circumstances known to an officer did not provide probable cause to search the individual's vehicle. Therefore, the circuit court correctly granted the motion, and you can see there. So essentially, they're saying that the odor of burnt cannabis alone is insufficient to provide probable cause for police search. That was several months ago when they ruled. Yesterday, the Illinois Supreme Court, on a separate case, made a different ruling. This is the case People v. Molina. Let's pull this up. They say, in sum, we hold that the odor of raw cannabis coming from a vehicle being operated on an Illinois highway alone is sufficient to provide police officers who are trained to experience and distinguish between burnt and raw cannabis with probable cause to perform a warrantless search on a vehicle. So the difference between burnt and raw cannabis, just to kind of show you where courts come down on how important definitions are. The Illinois Supreme Court saying that the smell of raw cannabis means it could be outside of a smell-proof container, which by law, state law says if you're going to be carrying cannabis, it needs to be in a sealed smell-proof container. So if an officer pulls over a vehicle and smells raw cannabis, they can search. Probably find some guy has some joints in a bag that's not properly, sealed up. But the smell of burnt cannabis can't be, because it might be emanating off somebody's clothes, like a passenger or something, from when they picked them up at a private location. I don't know. So regardless, interesting to see that. So we may have to talk about that in a totally separate segment with some of the arguments from the Illinois Supreme Court hearings on these. All right, so but bottom line, back to the top story here. An appeals court in Illinois, federal appeals court, issued a stay on the district court's injunction against the state's gun ban, meaning the state's gun ban remains in effect while the appeals court deals with it. It's Illinois in Focus Daily. Wake up with us each and every weekday morning here with America's Talking Network.